about topics that everyone wants to avoid. I just was having lunch with Daryl, Amy, Mal over there at that table, and these are topics no one wants to think you'll ever have to face: litigation, arbitration. And I thought I would talk about the why of alternative dispute resolution. That's really what arbitration and mediation are all about. And then it occurred to me there might be some of you here as I talked to Daryl and Amy about their business. They're in the threat mitigation business, taking people who are under stress, perhaps with access to weapons, and dealing with that. It's very interesting. And realize some of you may be here to hear a little bit about the how as well. And so, given the limited time that we have, I see that there are some lawyers, some very experienced lawyers who have been through arbitration and mediation. Are there business owners or business partners here who are interested in hearing about how to use mediation? Let me ask about that. Or hear about mediation. All right, terrific. I mainly want to make good use of your time and be as useful as I can, so I thought I'd say a few things about both mediation and arbitration for 15 minutes or so. Austin, does that make sense?
Yeah.
And then take questions.
Yeah.
Just a few seconds about what I do. I do, or have done for about 35 years, some litigation and trial work. And the last several years have been doing mediation and arbitration as the mediator and as the arbitrator. So let me start by making a distinction between those two. Mediation is not binding, arbitration is. So as I was talking with Mal here, the contracts that many of you may have with your business partner, with your employees, may have an arbitration provision in it. And that's how cases typically come to me or any of the neutrals that are here in Phoenix and around the United States. Lately, to my distress actually, many of those same agreements have mediation provisions that compel mediation before going to arbitration or to litigation, before the lawsuit's filed. And we can talk, I'll put that point aside, we can talk about that later, why I'm not a fan of those mandatory mediation provisions, which seem to be more popular in the Western US the last few years. Anyway, those are the differences. One's voluntary, that's mediation, and one is mandatory, that's arbitration. The second thing I'd like to say is be ready for a dispute if you're not in one. As a business owner or employee, you will be. And so the question is, should you get to litigation, or should you think about getting to arbitration or mediation first? If so, the time to think about that's now. Because the contractual provision is an agreement that you ought to reach right now. You can reach it later. The dispute, you can get in the middle of an argument with your business partner, and you can just agree to go to mediation. I see those all the time. But so as I say to my 33 and 29-year-old children, be ready, because the dispute will come. It's just the nature of the business. Next thing I'd like to say is be ready and be aware of who it is in Phoenix that's out there to help you resolve the dispute. I would say one of the biggest, if not the biggest, changes in the practice of law and therefore in the business community, certainly in my career since 1983, has been the popularity of mediation. Not true in the eastern half of the country. It was much more popular starting in about the 70s or the 80s. It's really, I think, although there were mediators, some judges who were doing mediation voluntarily in the 90s, it's really only become popular in the last many years. So your job, part of your job, is to make yourselves familiar with the members of the community that are out there, mostly lawyers like me, who are available to help get the dispute resolved. So how does that happen? Setting aside the easy availability of those names, they're all on the web. The question for you is, how can I get the other person to agree to get to mediation? And so my pitch to all of you is, if you think you're ready to spend $50,000 to $100,000 in a garden variety commercial dispute, then you don't need to ask this question. But if you're ready to take a shot at resolving the dispute, get to a new business agreement with your partner, keep a key employee from revealing trade secrets, keep a key employee from soliciting others in your business as they leave, all of those kinds of disputes you can mediate, and you can get it done, potentially, anyway, without a lawyer, and come to the mediation. Just had one last week between two business partners. They're two professionals here in town, and after spending a day, we agreed on the dissolution of their PC, and I hope, anyway, they're off and running. We got to a term sheet. They both had lawyers they were going to get to do a more comprehensive agreement. So that's what can happen with or without lawyers. For those of you who might either be in the middle of litigation or think that litigation is something you can't avoid, that's much more common. Those are the cases I see every day. I probably do 100 sessions out of 200 working days a year in either mediation or arbitration. They're almost all litigated cases. They have lawyers. They've all spent a lot of money, and the idea is to come to my office for a day and see if we can get it resolved. In most cases we do, and if we don't, we get it resolved in the next week or so. I'm working on one right now that didn't settle last week, a friend of Austin's, and I'm trying to get it settled using some techniques we could talk about here if you want. So, those are the tools that are available. And mediation and arbitration in Phoenix, let's talk about that for just a little bit, has become much more widespread. As I said, this is probably one of the big changes, I think, in the law practice over the last 30 years here. There are many lawyers, many non-lawyers, who are available to take the engagement as a mediator. Family law is a good area, a good example where there are non-lawyers who are doing mediations, but for the most part, there are family lawyers who later in their careers have decided to mediate cases. And so whether the question is custody or property division, those issues are getting resolved informally instead of moving along to the court. My practice is no different. My work as a mediator is no different, except they're commercial issues. Let me stop here before I say a few more things. Questions, thoughts, comments about the availability of mediation, comparisons to litigation? We could get down to the nitty-gritty and talk about a budget. Austin?
Yeah, I think that something that'd be interesting is seeing some of the real-world applications, maybe, of your mediation tactics. Like, you go into a room often with people who are bullheaded and have no interest in coming to an agreement. Your goal is to find a way to get them to come to an agreement. Is there some sort of, is there some aspects of that you think that you could use in a real-world commercial business situation when you're not at a mediation, but kind of?
Yes, great question. So the question is, how does the approach that I might take in a mediation apply when you're working out a problem that you've got in your business with an employee or a vendor? We all have to work through disputes or issues that threaten to become disputes. And I'd say two things. One is, what are the alternatives? And what I say to parties, I think, could be said to, let's take the example of a business partner, you're a 50-50 and a PC, and there's been a dispute about compensation. And what I stress from the outset in the mediation, I think you could say to someone, which is, what's plan B? And plan B doesn't look too good. And it's going and spending money on others professionals to help us resolve the problem. What can we do to A, save that money, and B, get on to the business? And of course, in the cases that I see, the alternative is a trial sometime in the next 6 to 9 months. So I spend time talking about how it looks in front of a judge or a jury and helping them assess their case. Because if it doesn't look very good in one room or another, I have a discussion about what the costs are if they lose and what the benefits are to put this behind them. Apart from asking, well, what are the alternatives, the second thing I'd say is, so what are the options short of Plan B? In other words, what are solutions that don't include either litigation or mediation? And there, for example, let's say you've got a buy-sell provision with your partner in the professional corporation. One of the solutions is one of you leaves. One of you leaves. And sometimes that means a partner getting bought out, and so sometimes there's a stated amount in the buy-sell provision in the operating agreement, sometimes not. So you need to focus on not necessarily always the costs and alternatives to resolving the dispute, but what's a business solution? And that can require some creativity from the mediator that the parties aren't able to give. So, other questions? I want to be useful. Yes?
If you already have a partnership without
Can everybody hear?
without a mediation agreement,
Right.
how do you go about adding it?
Well, ask. And I actually have a mediation submission agreement on my website. So that's the easy part. I think that I'm skeptical about trying to force someone to come to a mediation without an agreement to do so, because unless they're at least invested in the idea of mediation, it's hard. But ask. There's no law. I guess let me say this. There's no legal obligation to go to mediation. And in fact, once parties are in litigation, unlike, say, Florida, there's no legal requirement, practically speaking, in our Superior Court, there is a requirement to get to mediation because you're not going to get a trial date. But set that aside. So you really need parties agreeing to come, and that typically involves lawyers who say to their clients, this is something you should do. And that, I guess, leads me to the last thing I want to say is, in selecting lawyers, either to give your business advice or litigation advice, I think you should ask the question, what's your attitude about alternatives to litigation? You know, what's your experience in mediation? What do you think about my case as a candidate for mediation? What do you think about arbitration if there's a clause in your agreement? What's your experience? We can talk about how arbitrators are selected here in Phoenix typically. So, yes, Jimmy. Cool.
It feels like a good segue.
Yes.
Glad you remembered. Thanks.
Yes.
So, when I drafted
Jimmy's in
the
front of me in an arbitration right now with a client, so I have to be somewhat.
and it will be not germane to that at all.
Yes.
When I find myself drafting ADR provisions, I am in the habit now of designating a named arbitrator or named mediator. In full disclosure, sometimes that's you, but sometimes for other topics it's someone else. In your experience, are there cons to doing that? The pros are pretty obvious, but is there a cost? Because I haven't seen it.
I have seen it in valuation provisions, that is, people who will decide alone, typically an appraiser. I have seen people named specifically in those clauses. I'd be a little reticent about making that selection in 2018 and the dispute comes up in 2021, and maybe the community's changed a little bit, or you have different experiences between now and then. But those are modest concerns. I think those are modest.
So you've never seen a scenario where someone said, Shawn Aiken will be our arbitrator or mediator, and then a party said, oh no, I don't want that.
I haven't, because they're bound by that.
Right.
They're bound. And what I used to see more of, haven't lately because they just haven't come to me, are lease provisions with a selection by both parties of an accountant, typically, to decide one type of dispute or another. But I don't see those very common. It's not a bad idea. It's not a bad idea. Understand that these provisions can be drafted. There's no magic to this. They can be drafted in any way you like. So if you're a fan of mandatory mediation, or as Jimmy's pointed out, selecting a neutral in advance, then so be it. But I wouldn't be a big fan of either one, actually.
Well, just because you might not have full buy-in then? Why are you not thinking?
Of the mandatory mediation
Well, I guess
provision,
were you,
or the
are you saying
neutral?
you wouldn't be a fan of pre-selecting your neutral?
I wouldn't,
Well, why not?
because I might have a neutral who I thought wasn't sharp 5 years down the road, or who limited the alternatives I had with a client. The way arbitrators are picked, typically under American Arbitration Association rules, which is what prevails in this community, lists are sent out, and those lists of candidates may or may not include this person, and I'd be giving up the right for my client to select someone that I might be superior. I don't know. I can see the wisdom, but I'd rather not do it. Yes, sir. Question.
Are most mediators with law firms like yourself, or are they independent practitioners? I thought they were independent.
Yeah, that's an interesting question. They are some of both. I would say in Phoenix, my connection to my firm, because I am in a firm, is less common. So they're typically on their own or in much smaller practices. There's one practice with 3, Skelly, much more, and Overbillig here in town. But the problem of disclosures and conflicts gets to be difficult for arbitrators and mediators, and so as a result, they're typically not connected to larger firms. That's less true in the eastern part of the country. Has anybody had experience with mediation or arbitration here in Phoenix? Okay, fair. A lot of experience in some cases. What else can we talk about? I'm very interested in talking about what's on your mind. Yes.
Any thoughts on how to trim the costs of arbitration down? I hear that arbitration is a cost-effective alternative to a jury trial, but I often find it's not. How do they work on it?
Here's the sad truth. The problem is the arbitrators. In 2 ways. One is our fees. Whether it's 1 arbitrator or 3, they're actually, I forget the numbers from the AAA, but a very large percentage of the costs. And then secondly, you have arbitrators with differing views about how discovery and other expensive parts of the case, Luke, ought to be managed. So I don't have an easy answer except to say, interview the arbitrator and pick 1 arbitrator instead of 3. I mean, with those 2 moves, 1 instead of 3, which disputes of $1 million or more required under the AAA rules, and in interviewing your arbitrator and their attitude about discovery, you can save your client a bunch of money. I don't know, what do you think?
So that's the one thing that arbitration I've found helps. By definition, your ability to do discovery is dramatically lessened.
Yeah.
You know, you go through a jury trial and it's open warfare. Every client gets deposed and discovery goes on forever. And with arbitration, at least that is a big limiting factor. You don't get a whole lot of discovery. Right over here.
Luke, do you want to describe your practice you probably have had more weeks in arbitration than anybody in this room combined. Luke has a plaintiff's class practice based in San Diego, but has clients who are here in Phoenix, knows the defense community well, and arbitrators. You were just in a long one in front of Judge Skelly. And it's all around town, Luke. It's all around town. And your experience was what on discovery?
Great. I mean, you know, developer wanted to, I represent that would be construction. Actually, so they don't do the national builder developer.
Yeah.
One of the developers council wanted to close every home. A lot of homeowners, so they got to afford that. Unknown factors going into arbitration. A lot of times you have prevailing party attorney fees and costs. And prevailing party can put in a cost bill, and sometimes you get all of your costs, sometimes you get a lot of costs, but we didn't get our experts' costs. Because they're not taxable costs and non-taxable costs. We're hoping to get both. We get expert costs. That was one of the downsides of that arbitration. You know, it's a better result than the settlement.
So in the for what it's worth category, the American Arbitration Association, in fact they're here tomorrow doing this with some neutrals, is posting videos on its website. And the arbitrators are answering 4 questions. One of them is, what's your attitude about discovery and attorney's fees and costs? So part of the problem with arbitration is whether on Westlaw in the form of trial court orders or published appellate court opinions, there is no way to know how your arbitrator views issues like this. And I think the AAA is doing this for marketing reasons. I'm actually hopeful that this can be a resource for lawyers down the road.
Yeah. Watch it. I don't want to.
So business owners, this is one of the, I know it's alternative dispute resolution, but one of the things that lawyers bring, your lawyer brings to the picture is an understanding of your mediator and arbitrator. And that's the power. It's really the power of this whole process is you get to pick your decision maker. I mean, otherwise the cost and the energy is very similar to litigation. But you get to pick your arbitrator and you get to pick your mediator, and that is enormously powerful. We could talk all day about what follows from that, but that's maybe getting into things we don't either have time or you don't have the interest in covering. Yes, Joe.
I'm interested to say you get to pick your arbitrator, but it's like kind of like jury selection. You really get to deselect the bad ones. You don't get to pick the one that you get.
Yeah, I think that's true for AAA cases. In private arbitration, which is probably 2/3 of my work, so let's say I have 15 private arbitrations and 10, I think right now, AAA cases. The ones in private have agreed to. So they have decided, both the lawyers, without the aid of a list, to come to a particular arbitrator. And then, yes, what you say, Joe, is true about the AAA selection process, although I will say that you can go to the lawyer then and let's go to AAA and pick someone. And I think that's underused by lawyers. But you can just take the list and deselect. Yes, Heather.
2 things, Sean. One, could you kind of explain the difference between AAA arbitration and private arbitration? And then one thing that I was really interested to learn in the last year is that the AAA has panels of non-attorney mediators that you can use for specific business disputes. So if you could talk a little bit about that.
That's a great question.
That was really helpful in a case that I had, and I think it's an underutilized resource.
Heather is pointing out, again, that here in Phoenix and in most of the Mountain West, the American Arbitration Association, an organization that started in 1928, predominates in the selection of both arbitrators and mediators. And they have a website, adr.org. And Heather points out that on that website, you can go on and select non-lawyers, and I'll talk about another way in just a minute, or ask for lists to be generated of non-lawyers to help you resolve your business dispute. This is a very easy way for less than $1,000 as a fee to the AAA, although you have to pay for the time, to get your dispute resolved. So if I had to leave you with one concrete suggestion, it's write down adr.org. If you don't like wandering around in the private marketplace, and start there. Here in Phoenix, we are blessed with a very active regional office in Denver and a fellow named Lance Tanaka, who will also take your phone call and give you the list that Joe and Heather have talked about and I've mentioned, and you're off and running, and you can get non-lawyers. So to Heather's point, if the dispute between you and your business partner is an operating agreement with a bad buy-sell provision that didn't call for settlement of a valuation issue, and I see a lot of valuation disputes in my work, you could go get either a valuation expert such as Tim Gay, who's sitting right here in the plaid shirt, or otherwise, and have them help you resolve the dispute. Tim, any more thoughts on that?
Well, no, except that I'm not on the list.
You are on the list, Tim Gay, and have been for 40 years.
No, but I think what you're doing is you're continuing to circle the wagons, which is really good on the economics of your decision making.
Yeah.
And if you're working with good lawyers or other people, your own accountant, you should be able to put a pencil into your decision making. It doesn't take away the bitterness and the other parts of the dispute that probably exist. But, doing that as you and I have been involved in, so that's a really good idea. Make a business decision out of what may be otherwise.
Yes. Yes, you are making a business decision here on how to resolve the dispute, and it ought to include a budget, and that budget ought to include whether it's A, lawyers or not, and B, who your decision maker is, and put it in their hands. Thank you. See Tim later for his card. Other questions? Anything about the how? I don't know, we don't have, this isn't a group of neutrals, so I don't want to spend time about going through the day. You want to talk about submission agreements? Jimmy?
Well, actually, so this is kind of related to submission. I've trained myself to recognize early in the dispute when ADR makes sense, but I haven't yet figured out how to persuade the other party or opposing lawyer of the wisdom of early mediation or even arbitration early on. Have you, either as a neutral or as a litigator, learned of any tips and tricks to kind of help persuade, short of asking nicely and making the economic case, as Tim says?
Let me give you this suggestion, whether it's you or your lawyer, business owner or lawyer. See if you can get the other side on the phone with the prospective neutral. And whether it's before the mediation in the teeth of an unreasonable request like I had yesterday by one side to give a demand before they come to the mediation, we can get on the phone, the three of us, me and the two parties, and I think it is helpful for someone, a lawyer or a party who is wondering why, just to hear the voice and think through how the process is going to work, how the morning might go, what the benefits are. We're trying in the end to get to a term sheet. We want to get to a 2-page term sheet. People walk out with an enforceable agreement, and that's powerful. That's powerful to hear about that and understand that you can get a dispute, whether it's an employment or other kind of dispute, resolved with a half day's work potentially. I settled one yesterday for 5 hours that just had to get settled. Everybody walked out with a term sheet. And so I just think getting into the discussion can be helpful. You can't sit there and tell someone how helpful it can be, but it might help.
And do you think most neutrals, I guess you can speak to your practice, but I know you talk to folks. Is that typically something a prospective neutral will charge for, a phone call, or are they most willing to do that just to see if it's...
Yeah, it's 15 minutes to see if it's a fit. Just like the interview, which, by the way, I think is way underused. Interview prospective neutrals. It used to be, the neutral community was very resistant to that, I would say, as recently as 7 to 10 years ago, but it's become much more common now. So that's helpful. Joe and then Luke.
Yeah, just maybe share with us some of the techniques, because it's not, in my experience over a few years, that particularly when it's like a insurance, you know, it's like a commercial lawsuit where you got the plaintiff wants to get it resolved quickly because they want the money. The defendant has no concerns about getting it resolved early because they don't want to pay the money. And so you got that dynamic of, you know, the natural built-in unequal desire to seek out an efficient and quick resolution. Do you have any techniques or any ways to sort of nudge the reluctant defendant as to the advice of getting ADR early rather than late?
Oh, I thought you were going to say it during the
Shawn,
day.
you offered to address the mandatory mediation clause.
Yes.
And why you didn't like it. If you wouldn't mind, I'd love to hear that answer too, because I think it fits.
Well, I'm not a fan of mandatory mediation simply because often, for the reasons implicit in Joe's question, one side doesn't want to go early. And it's hard to get to a mediation when one side doesn't want to be there, for whatever reasons. So I'm not saying I like to see someone's teeth get loosened, if you know what I mean? But sometimes that has to happen a little bit before they get to a mediation, and that's hard when it's mandatory. Joe, the nudge that you're talking about, I thought you were going to talk about the session itself.
Well, I was going to, then I realized that's almost premature because you got to get them there first.
And the getting there part, the mediator has less influence over, but I have participated in these calls that I'm referring to. I really think that, I don't know, there's a very experienced employment lawyer here in town who has called on me twice recently for this very reason, to get on calls with plaintiffs' employment lawyers to try to persuade them to get to a mediation, just to talk about the process. Just talk about the process and what the competing costs are. And I suppose in cases where she wasn't feeling like the other lawyer was experienced enough. And I try to be even-handed about it and just talk about how much money people can save by getting to mediation sooner rather than later, especially in cases where there's no fee recovery. Yes, Ty.
What's your average mediation? How long is it to actually bring in the witnesses or arbitration?
The session itself?
To bring it in, start it, finish it. How long is the usually?
It's hard to do one in less than 5 hours, and most of them take a full day.
Now,
I did one yesterday in 5 hours.
I want to. What's the shortest one you've ever been in? It's productive as opposed to, thanks very much for inviting me, but I'm not interested, I'm leaving.
4 hours.
What's the longest?
The longest one?
Yeah. So I think we get
Into the next morning, 1 or 2 a.m. I started 9. I know people have gone, all the way into the following morning.
Have you ever had them that extend over weeks and months?
Yes. I had one earlier this year. We met in December, and we took a break. I interviewed the plaintiff, terrible case, posted the video of that interview to a secure web link. The defendants and their insurance carriers watched that. We convened for a second session in March, and we settled the case.
So it's an ongoing process.
Yes,
and
it's a
there's
process.
lot of different options. Things can change as you march along.
Right. Yeah, and I really encourage people at the end of a session, this one last week that I'm working the phones on today, and say, look, we got a long way today. Don't give up. Whether it's through me or not, here's the draft of the term sheet we ended with. It doesn't reflect an agreement, but keep it. And I say, I'm going to check in with the lawyers, and I do. And very often, 20, 30, 40 days down the road, the case settles. Where there are cases involving insurance carriers, they have to go back and, assuming they were convinced by the process, say, look, we got to put some more money on this case. This case got settled. I don't have the authority. Give it to me. And our mediator says we can settle the case. That's a powerful argument. That's powerful. Yes. The insurance company problem. Luke, yes.
Just two things, John. One, I only find myself in arbitration if it's in a contract.
Right.
If it's in,
You're not going to voluntarily go.
not me. And two, I found that ADR is not arbitration. ADR, in my line of work, is often an 8-step process that leads up to arbitration. And it's full of pitfalls.
Because you've got a clause that says repair first, and then if no repair.
You've got visuals, you've got mediate, you've got offer to repair. If they offer to repair, then they have to let them repair, and then, you have to formally meet before arbitration to try to resurrect mediation.
Look, you need to be working harder down at the legislature, okay? That's the first problem.
But one of the points is that whole ADR process leading up to arbitration. Oftentimes you find anti-tolling provisions, those all over the place. You gotta be real careful about what you're doing with that ADR stuff.
Yeah. Yes. And I think one of the points you're making is, depending on the simplicity or complexity of the clause, there's almost no option. You've got to get a lawyer.
Yeah.
I think I'm having in mind, hopefully this is helpful, a simpler clause that a lawyer or a non-lawyer could rely on and try to get their case resolved for the reasons Tim was mentioning. Joe, do you have your hand?
Yeah, I'm just gonna say, I think I may have steered you off the puck, but why don't you tell us a little bit about the techniques you can employ as a mediator when you get the barely good faith participation of a defendant?
I would suggest 2 thoughts, and I think these are all usable in your everyday work, your business. One is to say, okay, that wasn't helpful. But would you consider a proposal at X, or would you consider discussing with the other side proposals between X and Y? Either way. And that agreement to discuss either X or between X and Y, in the first case it relies on me, not the other side, to say it's going to be productive. And in the other, you don't have to rely on the other side being reasonable. You can say, well, I will move to $500,000 if they'll move to $1.5 million, and right now they're at 10. I don't have to rely on them moving. It's only if they will move. The second thing is I'd rely on your arbitrator or your mediator, or in your business dispute, somebody else, to say what they think is fair. I'm not terribly comfortable in this role until the end of the day, but I've gotten to the point, or maybe just the age, I don't know, where it seems to me, at least people who have come to me, deserve the chance to finally settle the case if they both agree. And I will, as I did in the one last week I'm still working on, or the one yesterday, say, do both sides agree? I can say what I think the case ought to settle at. It has nothing to do with the merits. I'm sorry, it has nothing to do with the merits. It's simply an effort to get the case settled. And if both sides say, yes, I will do that. And I'm very uncomfortable where they're far apart, and I've lately just decided, I'm not going to worry about that either. And if both sides say, yes, I'll do that. And even if they say no to the number, or one side says no, and by the way, that side that says no doesn't get to hear whether the other side would have said yes, they can at least take that back in the case of the insurance carrier, or in the case of someone with a board or an association, and say, here's the chance we had to settle the case. Our mediator says we can still do it. He's giving us a week to respond confidentially. And if there are 2 yeses, the case will settle. And so those are a couple of things I think that if they don't ensure agreement, they make the session potentially a lot more productive. And people seem, or at least after people have spent several hours with a neutral, if there's a high enough comfort level, then they are willing to play that game.
And you might want to also mention a little bit about the difference between so-called distorting and evaluating mediator.
Joe's pointing out a difference in the mediation community between directing the discussions without revealing a view on the merits of positions, facilitative. So that mediator convenes the session, directs the negotiation, carries out the agreement. The evaluative mediator along the way, so it's said, and I think everybody's evaluative, comments on the merits and says, Luke, I can't believe you think that argument's going to go anywhere. Let's move on. Let's move on. Tell me some other reason why you ought to get all the, that, not maybe in those words, but that kind of discussion. And so these are the kinds of differences in approach that your good lawyer will take into account in giving you advice about whether to get to mediation, and if so, in front of who. Good question. Tim.
You talked
How
about
we
the
doing?
legal aspects of mediation and arbitration.
Yes.
The people at the table, all of that. What I found in working with you on a couple of others, I think that part of the art is the motives.
The motives.
The motives of the other parties. Sometimes the attorneys on both sides. In that sense, to me, that's a special skill that's really important when it comes to a mediator. Something that's going to help resolve things. At least to get to the heart of it. How do you ascertain the parties' motives in your experience?
Two things. I try to have phone calls with just the lawyer in advance. And I say essentially, if not literally, is there something we should talk about while your client's not here? Because I don't say this. I know there is. I know there always is, otherwise you wouldn't be talking to me and you wouldn't have your client spend money in mediation. So that's one thing. And they're so productive, but I don't always have time to have those calls. The second thing is I will, and I have to tell you a quick story on this. I try to get the clients where I can talk to them either alone or just get the lawyer to let me talk. A lawyer a couple months ago did a very smart thing and said, Shawn, can we come over to your office at 8 instead of the 9:30, and I'd like you to just sit with my client for an hour, and I'd like you to talk to him. And I did, and this is a fellow who's been in the real estate community here for many, many years. We didn't say a word about the case. Just talked to him, heard about how he moved from Brooklyn out here in 1960 and came here, and how he grew his business. And did I learn much about his motives? Not really, but it was an important, it turned out to be a bit of rapport that I could rely on later in pushing the lawyer aside in this kind of, I don't say pushing, but I mean just focus on the decision maker who's right there in front of me. And so those are some of the things I do that I look for a chance to. Jimmy.
When I craft my mediation memos, I try really hard to give the arbitrator the information and evidence they're going to need to be useful in the other room.
Yeah.
However, I guess this is a really interesting point about what you're saying to Tim. Do you think it's worthwhile to include in your confidential mediation memos some personal details to help your mediator establish that rapport? And what would be helpful to you? I realize it was the conversation that did it here, not the knowledge. But
Yeah.
is there something that would facilitate that other than a meeting? Like what kind of info?
First of all, I think every lawyer should, almost every case, give the mediator a confidential memo. And I asked for it in my letter. But I'm not
You want
sure.
my assessment of their personality?
Yeah, I'm not sure it's the lawyer's job or how easy that's going to be. You just have to hope your mediator picks up on it. I mean, that's why we're listening so carefully. And we can see what's going on typically by about lunch. And by the way, always bring spouses. Can't tell you how helpful it is to have everyone in the room, even if they're not a party. We're running up against the time, Austin.
Yep.
Others? Thank you
Thank you guys all for coming.
very much. It's a treat. Thank you for the opportunity.